We're back live tonight here on In Focus, and thanks for staying on. Government has gazetted the final white paper on citizenship, migration and refugee protection. Home Affairs Minister Dr. Motsoaledi confirmed this during a media briefing yesterday. Cabinet approved the white paper last week following public participation on the draft policy. The paper seeks to overhaul the immigration laws and provide a framework for the granting of residency and citizenship to foreign nationals. For more on this, we're joined now by the Minister live on Zoom. Good to have you, Minister, and thank you very much for coming on. As I was saying last night, because of the connection, we couldn't continue. But 4,000 or so comments that you would have received on this paper. How do you measure widespread support?
Well, you look at the number of inputs that you are having and the number of people or organizations that are supporting a particular input. Of course, it's not an exact mathematical science, but you can see that the majority here are supportive, and of course there will be a few or so who do not support several aspects of the white paper. But all in all, the white paper received support from most of the people who gave inputs.
So you've got this handful who are saying that there is legal realities that are preventing this large-scale tightening of refugee laws. And you seem to have ignored that, one. But two, they are saying that you gave them a white paper that was impossible to interpret because of some of the defectiveness in terms of you saying exactly what is wrong with the law, what you seek to change, and what policy you plan to put in place. Let's start there, maybe as a start.
Well, from what I've seen, people are challenging mainly three things. They are challenging the issue of us withdrawing from United Nations Convention and re-acceding to the convention with reservations in terms of Article 42 of the convention, which many countries have done. We want to correct that because we haven't done it. Secondly, they are opposing the fact that we want to abolish Section 4.3 of the Refugee Act because we need to have it corrected, and they are also opposing what they believe we want to deprive people. Well, which they say we want to send people home to go and hang. Yeah. And that one is outright false. It's not true. I'm sure you have heard that. I heard some of your...
Yeah, so you are not challenging the principle of non-refoulement, is what they are saying.
Yeah, they say we want to do away with non-refoulement, which is an international principle. Let me explain, Thabo, because clearly they didn't understand what we are trying to do. The principle of non-refoulement, yes, we accept it's a universal principle. It is Article 33 of the United Nations Convention of 1951. It simply says you can't take back a person to the country where they ran away from if there is all the chance and evidence that they'll be persecuted, perhaps even executed in whatever way. So you can't say go away and go back to that country. That is Article 33. But that article has got two sub-articles. The first sub-article says that. The second one realizes that there will be exceptions. There will be people who come from such countries, but who are a menace to your own country, who are a threat to the security of your country, who are a threat to the stability of your country. So why can't you send them back? So they put in sub-article 2, which allows you such exceptions that under certain conditions you can refoul people. Now, what we are trying to correct, Thabo, is that in 1998, when the parliament domesticated this international convention into domestic law via the Refugee Act of 1998, Parliament domesticated only subsection 1, which said you can't refoul. Subsection 2, which allows you exceptions under which you can refile. It's not there in South African law. It might be there in other countries, but in our law, it's not there. And we want to correct it. That's why, Thabo, we suffer instances like, if you look at the stories of people like Rotov and Kresha, Fulken Skaishima from Rwanda, who was responsible for massacring 2,000 women and children during the genocide in Rwanda. And he ran to South Africa, he got refugee status. It had to need United Nations in Interpol to come and help us to search him. He has been arrested and they will help us to uproot him. Why should we be a country that is a haven for all these criminals? And the reason is simple. They say they look at our laws. You are aware, Tam. Many of you have called me for interviews about the Afghans who wanted to enter the country through Beit Bridge. Do you remember that?
Yes.
Yes. They've gone through, how many countries have they gone through? They went to Pakistan, they went to Qatar, they went to Zimbabwe, they went to Zambia, but only in South Africa did they start applying for asylum. Now, we are saying we want in our law to put the issue of the first safe country principle. If you are running from the Taliban, you don't find the Taliban in Pakistan, you don't find them in Qatar, not in Zimbabwe, not in Zambia. If you arrive there, it means it's the first safe country. Why insist on leaving all those countries and come to South Africa? Do you remember what their lawyer said? He said, we looked at your laws and found that the easiest country is to enter is South Africa. So we want to have refugees who, yes, are deserving to be refugees under the convention. Not just anybody who wants to run away from their country for whatever reason. And that's why we want to make these changes. Yeah.
So Section 43, what are the main features that will be completely overhauled there? And what are the new features?
It's not 43, it's 43.
43, sorry, yes, 43.
Yes. We want remember, we are saying the Citizenship Act of 1995, the the Refugee Act of 1998, the Immigration Act of 2002, all need to be totally repealed in their entirety. And we start from the scratch in one, we bring it as one law, one seamless law, with different chapters on these things, which will also include a law on on economic migrants, because it's not there. For instance, some people come and cry refugee status and all that, when actually it's just economic migration that moves them from their countries. That law is not there in our country. It's not even provided for in the International Convention. Why to include it? 4.3 is about children who are born of people who are not South Africans but are born on our soil. And they say if they stay there for 18 years, they've got an automatic right to apply for refugee status. It's in our law. But our question is, why don't they just follow all the other channels which other people follow when they come to a country to apply for naturalization, permanent residence, etc.? Why do we have to give a different channel in this case? And we don't understand it. That's why we want to change it.
But then they're saying that you don't put anything in the white paper that says you want to change it to what? You're just saying you want to change it. And I know you're saying you are looking at a complementary integrated bill that is based on the white paper that you are now going to put forward. But there is no policy framework that you're putting in place at this particular point in the white paper.
No, Thabo, what is the white paper? White paper are proposals upon which you are going to base a bill, which you will send to Parliament, which will go for public hearings, which members of Parliament will debate. Is then that they found the gist of what we want to do. The white paper is a proposal on policy. And our policy is simply that certain things need to go away. Our policy now is that we need to do away with the Citizenship Act that we are having. We need to do away with the Refugee Act and Immigration Act and start from the beginning. Should I start writing the act in the white paper? Is that what is being proposed?
So
I don't understand.
You are saying, I mean, even if they were to take this and challenge it in court on those grounds, that would be your, I mean, of course, you can't formulate defense on television, but in a sense, that's what you would be saying to the courts, to say, well, there is still a complementary process of integration where you come up with a bill and give those details.
I've never seen a white paper, a policy being challenged. What I see being challenged are bills. And I'm not a lawyer. I'm just speaking under my experience that throughout the 30 years of our democracy, I've never seen anybody challenging a policy in the form of white paper. People change bills, and we have not yet bills or acts. And they've not, in fact, they challenge acts because they can only challenge after the president has signed it into law. I've never seen anybody challenging a white paper. If there is such a thing, let it come, we'll see. It will be a new experience.
So I'm told there's a letter, I mean, I don't know the truth of this, that would have come also from former President Thabo Mbeki. Now, he was the president, and he's looking at your suggestion of reviewing some of the international conventions. And they're saying in that letter, it says, you don't illustrate in this white paper particularly what you are rejecting about these conventions and what you are suggesting, how it will be vastly different and guarantee that it will address the deficiencies.
It is from Thabo Mbeki Foundation. And as far as I'm concerned, he was giving inputs like any other. And if you look at the list of structures that they've given input, he is just one of those. And you are aware that not everybody who puts an input means that input will find its way into the white paper. It has never happened before. It was a proposal from their side. He said, for instance, certain things are not mentioned. In the final white paper, we've mentioned them. For instance, I remember the complaint that he says, we are just saying we want to pull from the convention and re-enter it with reservations. We are not showing areas that we are going to reserve. Look at the final white paper. You will find those areas. They are mentioned. In other words, we're taking a hint of that complaint.
And as far as the question of the number of illegal immigrants, saying there's a contradiction where at one point you're saying you don't know the number of illegal immigrants, but you're saying just the sheer number of them makes it difficult for us to calculate. Saying this is a contradiction. Do you know the number or don't you know the number? And you're using these proposals to justify. You're using the numbers to justify the proposals.
There is no contradiction, Thabo. Illegal immigrants are all over the country. All I'm saying is we don't know their number. Maybe let me explain what we mean. There are people who are asylum seekers, Thabo. Or let me start here. In terms of the South African Immigration and Refugee Act, in which we're trying to domesticate the United Nations Convention of 1951, its Protocol of 1967, and the OAU Convention of 1969. In the domestication, we are saying when you come to the borders and you say you want to enter the country because you are running away from your country because maybe there's war, you are being persecuted, there are natural disasters, we are obliged to give you what we call a Section 23 permit. That is in terms of Section 23 of the Immigration Act. It says that permit gives you 5 days to enter the country. You are entering illegal with no document, but you have announced yourself. It gives you a right to enter the country, but it says you have got 5 days to report yourself at the nearest refugee reception center. Right? And there are 5 refugee reception centers. One in Musina, the biggest one here in Marabastad in Swani, the Desmond Tutu Refugee Reception Center, one in Cape Town, the other in Kabeja, and the last one in Twekwini, in Durban. Now, when you arrive there and say, I'm an asylum seeker, I'm running away from my country, they are forced to give you, they are obliged to give you a Section 22 permit. That one is now under the Refugee Act. It gives you a right to be in the country for a period of 3 to 6 months, renewable, while you are applying for refugee status. If you win the refugee status, you are given a Section 24 permit in terms of the Refugee Act. You are now a bona fide refugee. You are under international protection. All those people who have got their numbers because they come and report themselves, we have got their fingerprints, we have got their photos. Other people who are guests in the country, come via visas. We have announced that we have got 17 visas in the country. Tourist visa, study visa, critical skills visa, general work visa, special visa, all those we know. But anybody who did not present themselves as such, how will we know them and be able to count them? Because we don't even know where they are. That's exactly what we mean. When we say we don't know their numbers, but time and again, you meet them because you are aware, Thabo, that we deport between 15 and 20,000 illegal immigrants in the country who are found. We send them to Lindela. And Lindela can carry up to 4,000. If you go there, at any one time, you'll find the number of people who are waiting for deportation. They were all illegal. So, but we don't know their specific number because it's not recorded anywhere.
So tell me about the 1.6 million. I mean, you are disputing, is it the UN refugee numbers that you're disputing with the 1.6 million?
Well, we were disputing numbers that they were saying we have got lesser refugees than other countries. But remember, the countries they are mentioning have got refugee camps. They put people into camps who are taken care of by United Nations also. We don't have camps in South Africa. But the numbers of those who come as asylum seekers, as refugees, I've just told you, because they are registered, we know them. For instance, we know by now that as we're speaking, there are more than 800,000 people who applied for refugee status, for asylum seeker status, and they were recorded, but they've disappeared. We don't know where they are. And we do know that the number of people who were given Section 34 permit are about 115,000, but their figures were much lower than that, as if such people do not exist. But we also know that the majority of people who are in the country, among those from which we deport 15,000, 25,000, 20,000 a year, who are illegal, is not known by anybody. There was an argument that South Africa put the number of foreigners in the country very, very low. And I spoke to the statistician general. He said they are looking for answers in the wrong place. Because Statistics South Africa said their job is not to determine the status of people in the country. Their job is to count warm bodies. And they count, with it, the information they get is what you tell them. He even gave me an example. He said, Minister, if we are counting women and we ask a woman if she's pregnant, if she say yes, we tick it. We don't go to examine her or go to research about the pregnancy, whether it's true or not. So if somebody comes to us and say, I'm here and I'm a refugee, they tick. And he said nobody will come to them and say, I'm illegal in the country. That's why even them, they don't know. Yeah. Because it's not their job, it's not their mandate to go and check the status of people. It's the mandate of Home Affairs.
So the other argument, I'm sure you would have heard yesterday, is that you want to curtail the right to work and the right to dignity. Just clear that for us.
I don't know. It's what they are thinking. If you look at the conventions, let me explain what the conventions say and what you are trying to do. The United Nations Convention of 1951 has got 46 articles. The United Nations was worried in 1951. Out of the 46 articles which are asking countries to do this and that, because they were written universally. Usually United Nations law are like the Bible, or the Quran, it tried to accommodate everybody. But the United Nations was worried about this. What if there's a country that is deeply worried by one article, which they know they cannot be able to afford, they won't be able to do, they don't have the capacity to afford it, but it's there. Do they then reject the whole convention on the basis of that article, whereby 45 of the articles are okay, but only one is difficult for them, or offensive to them, or impossible? What do they do? So the United Nations introduced Article 42, which allow you to put in exemptions, or reservations. Now, when countries do those reservations, if you read some of the reservations, I've actually put them there with the conventions themselves. They are saying we regard this as not as an obligation, but as a recommendation. In other words, they say we will try to do this, but where we will fail, we should not be bound to it legally. That we fail to do this and this so that you get punished. Now, in our case in South Africa, We only entered the convention on the 1st of December, 1996. And we entered with no reservations. What does it mean? It means you are telling the world that come here, anything you want, which is in the convention, will give. Now I'm asking you, Thabo, is it true? Does South Africa have got resources or the wherewithal or the capacity or the ability to provide anything to anybody who comes in the country? As we don't have any reservation. Do we have that capacity? Are we able to? And I'm sure you are aware that is not true. So why should we go online to the world?
And finally then, Minister, what's the process now of the complementary integrated bill based on this white paper? When is that process going to kick in?
No, the bill must now be drafted and be presented to Parliament. Parliament will take it to the Portfolio Committee on Home Affairs. The Portfolio Committee will do public hearings on the new bill. Members of the public will come in again, and the Parliament will then debate it, pass it or reject it or change it in whatever way, and send it to the President to sign. Then it becomes law. That is the process that is waiting to follow.
And when is that process going to start?
Of drafting a bill?
Yes.
We've already started, but I can't say we are going to submit it when. We have already started drafting a bill. It's not a one-day job. It takes quite a while.
Yeah, no, indeed. And finally, just clarity on this. 32 survivors of the Usindiso building fire recently deported. What do you know about that?
No, the court said we can't deport them until they have given their evidence with Kambembe Commission, and we're waiting for them. I haven't checked the last time because, remember, there was a magistrate court that said they can be deported. But they went to the High Court, which say wait until they present to the Kambembe Commission.
So as far as you know, there would not have been any deportations on those 32 survivors?
I think they would have told me if they were going to deport them. Officials will tell me because it's a matter that is in the public eye. That is a question of a commission that was in the High Court. They can't just act unilaterally without me knowing. So up to now, I don't know. And then I conclude that nobody was deported because I wouldn't understand why they can be deported secretly. That I wouldn't accept also.
Minister, we appreciate your time. Thank you very much for coming on. That's the Minister at Home Affairs there, Dr. Aaron Motsoaledi, clearing some of those issues with regards to the immigration laws in